ahead and get started. Everybody can continue to join. Hi, everyone. My name is Callie Smith, and I am the Director of Communications for the ECAC. I want to thank you guys for joining us today. We are very excited for the two excerpts we have in front of us. So I'd first like to introduce our moderator and ECAC part founder, Bob Kobeck. Go ahead, Bob.
Hey there. It's nice to be introduced by Callie Smith, the communications coordinator for the ECAC. This will be fun. It's going to be an interesting experience. So you want me to introduce Aaron?
Yeah, I'll go ahead.
Oh, hey, so you can tell we're so well choreographed. Aaron Perry, attorney with McMurray and Schuster, is a privacy expert, former Ohio State player. I'm sorry? Somebody say something?
I don't think so.
Okay, well, maybe some feedback. Anyway, Aaron is going to go through not necessarily state by state, but a good overview of what's going on with privacy. And as we all know, if you've been around the contact or communications industry for any length of time, we have all gone through the death by paper cut with the TCPA. So while we're going through this state by state, just keep in mind that the ECAC is also working pretty hard to get a national privacy law established so we can preempt the state laws. Aaron, I've said that out loud. I probably shouldn't have, because if there's an AG anywhere within shouting distance, they know they're not going to like that. So Aaron, why don't you go ahead and you can get started, and then if you don't mind, I'll ask you some questions along the way. And if you, as a guest, have any questions, just raise your hand, and we'll pick them off as we go.
Awesome. Well, yeah, as Bob mentioned, I'm Aaron Perry. I'm a regulatory compliance attorney. I spend about 98% of my time in between data privacy and telemarketing. So this intersection is just up my avenue. And in recent years, data privacy has kind of become the center stage for lawmakers, regulators, and really consumers alike. What was once a niche concern is now certainly a state and probably global priority. And we've seen a growing patchwork of privacy laws emerging pretty much across all jurisdictions. Some of these are sweeping and comprehensive. Others are narrowly tailored to specific sectors or data types. So while not every regulation will directly impact call centers or BPOs, it's essential to stay in the know about the broader legal environment, because privacy compliance isn't just about checking the boxes. It's also about this larger building consumer trust. So for BPOs, call centers, embracing privacy is kind of a strategic advantage in a sense, because it signals to clients that we're committed to operational excellence, but we also respect individual privacy rights. It's super important to consumers in a world where data is power. Showing a consumer that we handle it responsibly speaks volumes. I do have to give my quick disclaimer here. I am an attorney. I'm not your attorney for the purpose of this call. So Bob, we've got a lot already on the plate, and this map kind of summarizes that. This is the patchwork of those privacy laws that have kind of caused the paper cuts for us. Green is in effect now. There's 19 states that have comprehensive privacy laws. Most are in effect now. We have a couple that will take effect later on next month, and then a few later on this year, rounded out by a couple that will go into effect right at the beginning of the year. So The number one question is determining whether your business is a controller or service provider. It's crucial because it affects the legal obligations under privacy laws. So when we're talking controller, we're talking about the entity that determines what we do with the personal information, how it's used, how it's disclosed, how it's processed. We're talking about a service provider. That is an entity that processes personal information solely on behalf of a controller. The service provider gets personal information, but is restricted from using it for any purpose. They can only use it for specific purposes that are clearly enumerated in a service provider contract. So understanding that difference is crucial, because if you're a controller, all of the obligations under privacy laws apply to you. If you're a service provider, the obligations aren't going to directly apply. They'll indirectly apply through service provider contracts. Maybe you call them a data processing addendum. But nonetheless, that's the key determination here. And as you can see on the screen, there is essentially three thresholds that can sweep a business up. The first is a monetary or revenue threshold. That's actually only a California standard. There's a control process threshold. If you can control or process a certain number of consumers' personal information in any given year, then you may have compliance obligations. And then the revenue plus sales share threshold. If you derive a certain percentage of your gross revenue from selling or sharing personal information, plus you control or process a certain number of consumers' information, then you have compliance obligations. Important to note, to Texas and Nebraska do have a slightly different applicability threshold. Those laws apply to any business that's directs products or services to Texas or Nebraska residents, and processes or engages in the sale of personal information, and does not qualify as a small business. So Bob, as you mentioned,
I have a quick question on your definitions, particularly controller versus providers. Those definitions seem to mirror the GDPR definitions. Is my perception correct on that?
that is correct. And if we just think generally, you know, we know that the business with whom the consumer interacts should have primary obligations. They're the one that's going back and forth or has the primary relationship with the consumer. But then we also know that there are other entities that provide services to that business, and it's not enough that a business can say, well, I sent that over to my service provider, so they can kind of do it, treat the personal information however they want. It just makes sense to flow down certain obligations to service providers. So you are right, Bob, that this is a GDPR setup, and it's something that any federal privacy bill that we've seen introduced retains.
Yeah, and I also thought it'd be important to mention that when we're talking about communications and privacy, we're talking about anything that's omni-channel. I mean, it could be email, it could be text, it could be chat, it could be phone calls, inbound, outbound. So anytime you're dealing with a consumer, correct?
Yep. Any time we are collecting information that can reasonably identify an individual, that's personal information. So like you mentioned, when on a telephone call, we may be collecting personal information. Our obligations under these laws are in effect. Similarly, and something that's probably more overlooked, is this automatic collection on our websites? You know, do we have cookies that are automatically collecting IP address? IP address is a specific type of personal information. It can be used to relate or identify to an individual. So really any type of information that is going to be relatable to an individual is in play here. So we've got to think of
with using any vehicle.
any vehicle. Yep. Yep. So you're right. It's across all channels, all collection methods. What are in these laws? You may have heard of the consumer rights. Those are the primary vehicle that consumers can have control over their personal information. And familiar rights are right to know what's this business collecting about me, right to access. We have to give them a copy of all the personal information we've collected about that individual. Right to delete, they can ask us to delete certain information. They can ask us to correct certain information, opt out of sales or profiling for legally or significant effects, and targeted advertising. Targeted advertising is that cross-context behavioral advertising where we're collecting information on one site to advertise on another site. So those are the flavors of rights that consumers have to, like I said, kind of get control over that personal information.
This is consistent pretty much in all states.
Consistent across the board, minus the appeal right, where consumers have the right to appeal a decision to deny a request. There are several exemptions to fulfilling any one of these rights, and if an exemption is exerted and the consumer wants to appeal that decision, they can. Most states specifically provide for an appeal right. We'll get into the limit use of sensitive personal information. That's a California only right in a few slides, but yeah, for the most part, these are pretty standard across the board, and we'll certainly see these some variation of these in a federal privacy law or bill. And then you can see also that these laws get pretty specific about other aspects of offering these rights, method, how we authenticate the person making the request, what we can do once a individual makes a request, including not discriminating by raising prices or otherwise making it hard for the consumer to use the products or services. Data privacy principles and data security. So these principles have kind of been around since the advent of privacy laws. If we go back to our first federal privacy laws in the 1960s and 70s, these are going to be pillars of those laws, and something that we would totally expect to a federal privacy law to include. And these kind of set the foundation for what information can we collect? What can we use it for? How long can we retain? And a core part of our comprehensive privacy laws is a data protection assessment requirement. This is a in-depth assessment where a business has to weigh the pros and cons of processing personal information that presents a heightened risk of harm to consumers. So that's kind of a GDPR type requirement that has bled over here into state laws. Data security, this is this kind of goes without saying. We really don't need a law. We don't need to look to these comprehensive privacy laws to understand that we have to take reasonable security protections to keep personal information safe, these laws just take it a step further and say you have to keep this information safe. Minnesota introduced this data privacy and privacy policies and procedures obligation where businesses have to maintain a specific policy that details the procedures and methods that they are using to comply with the law. So interesting, kind of nuanced obligation coming out of Minnesota. But once again, these privacy principles have been around as long as privacy laws existed, and are a good foundational piece for putting together a use and retention policy. Sensitive PI is a category of information that reveals very intimate details about an individual, and is intrusive if it's disclosed, or just overall deserves greater protections. And if we think of what that might include, that might be racial or ethnic origin, religious beliefs, health conditions, financial information, certain access or password codes, just that intimate information that deserves extra protection. And state laws and GDPR and anything that will come out in a federal bill will retain these heightened protections for sensitive personal information. The number one way that we really see a difference in treatment is states either have a consent to process, where we have to get consumer consent to even collect and process this information. As I mentioned earlier, California has a different approach where they do not require consent necessarily to collect sensitive personal information, but they do require businesses to offer a right to limit sensitive personal information for uses that are not enumerated in the CPA regulations. And as you can see here, a couple states take it a step further and have some very strict prohibitions on collection and use of sensitive personal information. And as I mentioned, this is something that would definitely bleed over into a federal law. We've already seen sectoral federal laws that govern that more sensitive personal information. Think like the Gramm-Leach-Bliley Act or HIPAA or any of our educational privacy laws. So this heightened protection for sensitive personal information is not going to be going anywhere. Included in our privacy laws is several disclosure obligations. If the purpose of these laws is to empower consumers to make decisions and have control over their personal information, well, then we've got to tell them a lot about what we're doing with it. Yeah, we've all seen a privacy policy. I recommend reading those things. I've probably drafted a couple that you may come across. It's I think it's beautiful prose, kind of Shakespearean like. So next time you come across one of those, read it. It just might be yours truly that drafted that one. But the information is that we have to include in a privacy policy pretty much similar across the board. You know, what information are we collecting it? Why are we collecting it? What information are we disclosing to other parties? And how can consumers have control or a say in what we're doing with that information? There's all kinds of specific requirements for privacy policies, where it has to be placed, what we have to do in terms of any changes to the privacy policy. But one other disclosure obligation out of under the CCPA is a point of collection notice. California requires that anywhere we collect personal information, we have to give some disclosures about that information. It's going to largely mirror what we have to give in the privacy policy, just a lot less information there because we do have to give this every time we collect personal information. Which
CCPA, meaning California, right?
correct, yep, that's the California privacy law, and it's
That's the one that an awful lot of the state laws are being modeled after.
that's correct.
And it the downside of that one though is it has a private right of action, right?
It's very limited. It does indeed have a private right of action, but very limited for data breaches. So not anything related to consumer rights or even the data protection assessments or privacy policy, just limited to breaches of data security. But nonetheless, it's there and it's available if we don't have reasonable security protections in place. Now, there are some of those topic or sector specific privacy laws that do have a private right of action. Think like the Illinois Biometric Privacy Act. It is a the Illinois legislature has reduced the grab that private right of action has, but historically it's been an often litigated law. There's a Washington My Health, My Data Act that carries a private right of action too. And the private right of action is probably that, and preemption is the main holdup in a federal privacy law. The legislatures at the federal level cannot get past whether a federal bill should include preemption rights, which means it would wipe out state laws like the CCPA, and then also whether consumers should have a private right of action to help enforce and protect their rights under those laws.
Well, in the case of preemption, particularly with respect to the federal law, if there's one thing that will bring Republicans and Democrats together, it's the congressional delegation to California that will say, "No, you're not preempting our stuff at all." And I mean, the Republicans and Democrats in California, they'll fight that tooth and nail.
Oh yeah, the California delegate,
All of them.
they've already written several letters and have really campaigned hard to prevent preemption. So you know, and the California delegate makes up that they're very powerful in Congress.
There's a lot of
Yeah, and each one of them has pledged to fight hard to prevent preemption. So it's going to be a war in that aspect.
it's a hard sale.
Yeah. One of the APRA, the American Privacy Rights Act, which was introduced last spring and didn't really get the traction that we thought it would, had bipartisan support, had bicameral bipartisan support, a Democratic senator and a Republican congresswoman introduced it. And we thought that because it had both bipartisan and bicameral support, that it would be one of the bills that would probably move the quickest, and it really didn't. But it did include a private right of action that allowed for actual damages, injunctive relief, and reasonable and attorney fees for specific violations. It wasn't for any type of violation under the law, but just specific. And
one of the compromises there is with the attorneys general by saying that, okay, the FTC or the FCC, whichever body ends up governing the private, the PRA particularly, just deputizes the attorney general in a particular state, and then the whole thing falls back to the state, so the state can still collect the money.
Yeah, right. And it would be the FTC that, at least under the APRA, the APRA would have required the FTC to create a new bureau to administer the law and to kind of carry out the functions, including investigative and enforcement authority. And like you said, they would pass that down along to the states.
Yeah, and I mean, because it was the states that were the biggest killers of preemption for the TCPA. The AGs are the ones that fought that tooth and nail. So I don't see any reason why they wouldn't fight this unless there's some compromise, which that could be the compromise.
Yeah, and I think that's probably where it will land. Like, hey, you can help enforce this too, and you can even have a share of any damages recovered in the investigation too. So I think that could sweeten up the pot. But once again, we have the California delegation that is fought tooth and nail to prevent preemption. So it'll be interesting to see how they continue to iron this out. As for preemption, the APRA did preempt comprehensive privacy laws, but it did not preempt certain state sector specific laws unrelated to privacy or data security, in the sense that comprehensive privacy laws regulate that. It would have not preempted like that the Illinois BIPA, the law I mentioned there a few minutes ago. So they did kind of carve out some of those sector topic specific laws, and would still give states power to control that. Oh, one thing. Let me get back here. One thing I was mentioning with the enhanced disclosures, there was that California notice at collection, and that notice at collection has to be given anywhere we collect personal information. So even on a call, if we are collecting personal information on a call, we are going to have to make some disclosure that covers the point of collection requirements. Now, the point of collection requirements can get pretty lengthy, and typically it would make up like a 5 or 6 page document just with typing out the words alone. So I don't think their intent is to make our agents sit there and read a 5-page document every time they get on the phone. But we have to think about how we can substantially comply with this requirement. A lot of businesses that take personal information over the phone now give some type of recording, like it usually comes after the call recording disclosure. It might say, we record this conversation for quality assurance purposes. For more information about the personal information we collect on this call, visit our privacy policy on www.business.com. So it's not necessarily that we have to sit through and read a novel every time we get on the phone, but we do have to take some action to give them notice about where they can find information about the information we're collecting on the phone.
And it's a really big burden on those industries that are already regulated, like banking, collections. I mean, there's already just a ton of regulation sitting on top of them, and you add this into the compliance process. That, I mean, I would think those industries would be involved in looking for a workaround to it.
Right. And as the disclosures grow, especially a pillar of our early AI laws is that we have to disclose that to the consumer that they are talking to AI and not a human. And once we start adding recording disclosures and call disclosures and privacy disclosures and AI disclosures, it can make for a pretty long message. I had to call my bank the other day, and when I dialed into them, I got their IVR, and I mean, took a solid minute for them to get through everything they had to tell me in order to protect their behind. So it's a substantial burden, but is in line with empowering consumers by giving them information about our collection practices.
Well, it's about trying to get members of Congress and members of a legislature to understand that everything they want to accomplish can be accomplished with a process. You know, if they would just understand that there's some process engineering that can happen to accommodate those consumer rights, because like we said, I mean, banking today has regulation on top of regulation on top of regulation, and this is just going to add one more component, which adds more cost, which it's not a hidden cost to the consumer, because they pay somewhere somehow.
Yeah, and those disclosures on a phone call are even harder, because the call drop rates go through continue to rise as there's more levels of disclosures and verification. It can really frustrate the communication process, especially on the phone. So I think, God bless our legislators, but these folks are not specialized in every area of commerce. They have to make laws to regulate that, but they're not specialized, and sometimes they overlook the immense burdens that they put on businesses. So
If I were going to give a pitch for why you'd want to be a member of the ECAC, you just gave it.
I love that. Yeah, I would recommend it to anyone and everyone.
Where we can help.
So moving along, as I started out with the crucial question, am I a controller? Am I making the decisions about what happens with this personal information I collected? Then I'm a controller. If I'm solely processing personal information on behalf of a client, they tell me what I can do with it and impose certain obligations related to that information. I'm not free to do with it what I want, then probably a service provider. And controllers who have primary obligations under this law have to execute a service provider contract with any service provider that they use. And these contracts have to have specific obligations and requirements in them. It has to set forth the nature, purpose, duration of the processing activity that the client is asking the service provider to complete. The service provider has to commit to strict confidentiality with the information. That they would be required to delete or return the personal information on the controller's request. There's some states require that the controller has certain audit rights in order to be able to demonstrate compliance to the controller. And then just general.
So they can self-audit?
Yeah, the controller can self-audit the service provider. Some states provide a pathway for an independent third party to be able to audit the service provider. But I will say these audit rights are not very in-depth. It's kind of a one-liner in the laws. Controller has the right to audit. So if you're a service provider working with controllers, there are ways that you can limit the burden that an on-site audit would have. Some service providers will say no on-site audits. We're only going to do a virtual audit through the exchange of information. Some will limit the number of hours they'll dedicate to a audit. So there's ways, if you are a service provider, that you can kind of box in that audit right, but it does exist, and the controller who does have those powers, and you know, generally speaking, one of the big recommendations is that controllers, you know, exercise some due diligence over the service providers they select. You know, if you're a controller, you want to have some insight into how the service provider is going to protect and assist you in protecting personal information. There's a third-party contract requirement in California. A third party is easily defined as someone that's not a controller and someone that's not a service provider. So think of situations where you're selling personal information to another entity that is not restricted from using it for certain purposes. You are selling it to them. They can do with it as they please. That's the third party here. There's contract requirements in California. They're less onerous than the service provider contracts. And in terms of the APRA, any federal privacy bill will have service provider obligations. We've seen it in every sectoral federal privacy law. Think under the GLBA, we have the business associate standards, and it's kind of a pillar of those laws to have protections for service provider processing scenarios. So enforcement, you know, no private right of action at the state level, minus that limited data breach private right of action in California. Usually it's the AG or some department of the AG that has investigative and enforcement authority, and the punishment is typically about $7,500 per violation. In other states, Colorado, they count theirs as violation of their broader consumer protection statute that carries a $25,000 penalty per violation. And this is
defined per violation. Is that so? If a data breach includes 1,000 people, is that $75,000 fine?
Yep. Just think like the TCPA. You know, it's
like
500.
Okay.
$500 to $1,500 per violation under the Telephone Consumer Protection Act, and that is per call. So it can add up quickly, and as we know in the TCPA land, TCPA cases can quickly become bet the company cases. So same with our privacy enforcement, just that it's not the consumer that's enforcing the law, it's the state entity. The good thing,
does that include a breach?
so just in California, it includes a breach, but we have, all states have separate data breach notification laws that set out. Yep. And about a dozen of those state data breach notification laws have a private right of action for individuals whose data was compromised. So for the data breach, there's a separate governance that some states do give a private right of action to enforce.
Yeah, one of the one of the benchmarks in my business. We deploy, I don't know, 10 million surveys a year. And so one of the reasons that this is something that is of concern to us is that if we're sending a survey for a resort or a bank to measure a customer's experience, and we've got, and it's a national company or an international company for that matter. Every time a state passes a new law, we have to go in to tweak our software. I mean, and so for anybody that's anywhere in the omni-channel communication business, keep in mind that every state has something unique that is going to cause you to drill down and take another look. And
Yeah,
probably fix.
Yeah, that's a great point. You know, as more and more state laws are passed, there is going to be more and more nuanced obligations that are going to require a reevaluation of our compliance program. Now, luckily, there hasn't been a law that just kind of flips everything upside down, but there has been several laws that include several more nuanced or more onerous obligations. Maryland and Minnesota would probably be the two laws that came to mind. They were both passed last year, kind of, you know, 15th or 16th to throw their hat in the privacy land, and they diverged more significantly than any other law that came after California, which was the first state to pass their privacy law back in 2018.
Oh, it's kind of like that. It's kind of like that, you know, that old, we used to be that cold capsule that was sort of, you know, the tiny time pills that would just sort of explode in your face every couple of seconds. That the last bill that got passed is going to be the model for the new bill that's going to be introduced.
Uh-huh.
And so, you know, I remember one time it was, oh my God, Virginia's coming out with one, and you know, then it took Virginia, and right now Indiana passed theirs 2 years ago, and it's still not going to be out until 26.
Right.
You know, what are they going to do in the meantime to identify the intent of the legislature? You know, I know what the legislature meant because I helped lobby that bill, but that doesn't mean that the people that are fashioning the regulations are going to live to the true intent.
Right, and only a
They have
few.
their own brand of tweaking.
What's that?
They have their own brand of tweaking.
Yeah, that's correct, and only a few, 3 states specifically have corresponding regulations: California, Colorado, and New Jersey. But legislatures will quickly amend the privacy laws to make up for anything that didn't initially carry out their intent. For example, Oregon's privacy law just went into effect last year, but they've already made two amendments this year, including a pretty significant one that we'll hit on here just on the next slide. To tie up this enforcement slide, there is a right to cure under several of these state privacy laws. That's great for businesses because they give you a certain number of days from when they give you written notice to cure any violations that they think that you might have. Now, for a good deal of the requirements under these comprehensive privacy laws, that cure period will be enough time to get a policy and procedure in place to remedy that alleged violation. But there are just some aspects of these privacy laws that takes a good amount of time for implementation and consideration, and the cure period may not be enough time for some of the more complex obligations. So it's good to know that we have, but for the most part, we don't want to tailor our compliance plan on knowing that we have a right to cure available. Just not a very good practice, and we should aim for full compliance, knowing that if something is going a little wrong, that we have some time to fix it up. So as I mentioned, there's a few legislatures that really are considering what shortcomings their initial privacy law had, and you can see how Montana and Oregon have already amended their privacy laws that have only been in effect for a year. Scope of these laws has been a big conversation amongst scholars and legislators alike. The whether applicability is enough or whether they should broaden it is always a question. The exemptions that these laws provide is similarly ripe for discussion. You know, generally GLBA entities are going to be exempt from a large amount of these privacy laws, but we've started to see states walk that entity-based exemption back to just a data-based exemption, meaning before, if we were a GLBA regulated entity, no obligations under these privacy laws. Now they're saying, okay, well, the financial information you collect is governed by GLBA. That's fine. No compliance no secondary compliance obligations for that specific financial data. Everything else, any marketing data, any automatically collected data is going to be governed under the privacy laws. So just some interesting applicability changes under Montana's law. And then Oregon has passed a bill that is pretty substantial, in that it will prohibit selling personal information about individual under 16 years old, and would prohibit selling precise geolocation information. Now, these prohibitions under the Oregon, this new Oregon amendment, there's no consent exemption. Now, there's the way that they define certain terms, like sale, generally excludes situations where a consumer directs us to share their information. But it's worth noting that these prohibitions do not have a outright consent exemption. You would have to work to figure out how you could continue these activities without relying on consent.
Tell me this, what is, can you jump back one? What is GLBA? What does that mean?
That's the Gramm-Leach-Bliley Act. That's the federal financial privacy law. Any financial institution that collects non-public financial information has very stringent protections related to use and disclosure and security. Mirrors our comprehensive privacy laws, incorporates a lot of the provisions that we've discussed, but it's the federal sectoral specific privacy law governing financial institutions.
Okay. I just quick point of order, Counselor. We've got about 7 minutes.
Yeah. Well, let's move fastly through these, and if we have any questions, we'll continue to watch for that. But we'll go quickly through these. So regulation tracker, the big news here is New Jersey just recently released their comprehensive regulations. These are the 3 states that have regulation power. I would recommend, if you're a controller subject to New Jersey's privacy laws, to take a look through there and determine if you want to make a public comment before the start of August. Enforcement, I'll move through these quickly. We're going to provide this presentation. So in the event that we pass over something you're interested in, just take a look at it later and let us know of any questions. But generally the CCPA, the CPPA, the enforcement body out in California, has begun their enforcement. They're past implementation stage for the most part and are now sweeping certain industries or certain technologies and starting to enforce the requirements under their privacy law. A lot of it has to do with our disclosures, lack of or inadequate disclosures, and then just general collection practices, especially some related to collection practices for verifying consumer privacy rights. They also do issue advisories. They've issued a couple to date, one around data minimization to consumer requests, kind of what I just hinted at, and then the harm of dark patterns. Dark patterns are designs that may not be intended, but that have the effect of subverting consumer privacy choice. In Connecticut, they're active as well. Their AG reports dozens of notices of violation and information requests, generally centered around inadequate disclosures, failure to provide certain opt-out mechanisms, and then a lot having to do with specific sensitive personal information of minors or health data. Oregon, kind of the same way. They're active sending violation notices out. Their big thing is lack of or inadequate disclosures, and we've worked with a couple clients that have received some of these notices, and they're very specific about what they want, what they imagine compliance with their law looks like. Texas, just important to note, remember Texas is one of those states that has a different applicability threshold. If you're providing products or services to Texas consumers, selling PI and not a small business, you have compliance obligations there. But the Texas Attorney General said that they intend to be the #1 state privacy enforcer. And so far they've come out swinging and have quickly issued notices and filed lawsuits. So Texas is kind of a hotbed right now. The consortium of privacy regulators, this is important to note here because we've always known that regulators kind of sometimes share information about enforcement actions, to the extent that they can, and kind of work with each other. But the privacy regulators have formalized their group, and it's just good to know that this exists, because we will see coordinated enforcement actions, and we will see a sharing of expertise in the sense that one state may determine something's necessary, and then we'll see that trickle down to all the other states. So just know that this could lead to higher enforcement risk, increased need for compliance, consistency, and proactive governance is a must to really stay on the right side of this consortium. Don't forget the FTC's enforcement power. They regulate privacy a lot through their Section 5 UDAP enforcement. They are granted the power to prohibit unfair or deceptive acts and practices, and they have used that to shape their privacy enforcement. So even without a federal privacy law, the FTC still has power to regulate privacy practices. I'll skip over. I have some topic-specific privacy laws that are important, but may not reach everyone. Health data privacy laws, data brokers, those are those parties that sell personal information to another party that they did not collect directly from the consumer. Several states have child privacy laws now that govern any information collected from someone who is younger than 18. No younger than 18. That is a vastly different standard than COPPA. Federal child privacy law applies to 13 and under. These state child privacy laws bump the definition of child to anyone who's younger than 18 years old of age. So if we're doing something like work on behalf of an educational provider, that may very well implicate these privacy laws designed to protect children. A few other laws that we pretty much touched on. So in order to wrap it up here, so what can we do to stay ahead? Well, first is determine what laws are applicable to us, and then we really want to try to create one compliance procedure and policy. We don't want to have 10 different policies or procedures for any type of jurisdiction or law. One central policy, and we tend to think that should be the aligned with the most stringent requirements. Monitor and keep up to date with what the regulators are doing to see kind of what's on their enforcement radar. And then consider privacy by design approaches at the start of implementation. Don't wait until something has been implemented to start considering privacy. Make that a consideration right at the start. Manage consumer rights appropriately. Consumers care about their personal information. If we help them care about it, they will have a lot more trust in us. Review contracts and audit performance, determine what our contracts need to say in them, make sure they do. And then lastly, Tom Coughlin, the Super Bowl winning coach for the New York Giants, had said, "You're only as good as the last man on your roster." That's the same in privacy world too. Your privacy plan is only as strong as the last employee on the list. So make sure that executives are trained clear down to the person emptying out the trash can every night. So
let me kind of help. I mean, go ahead, Aaron.
Oh, no. Go ahead, Bob. I was going to flip it back to you anyhow.
Well, I think the last slide in your show has your contact information, doesn't it?
Yeah. Well,
there we go. Well, here's the thing. For anybody that either visited with us in this particular time or anybody that would view the recording, there's a reason that the ECAC asked MS Law to do this, to provide this information. And it's because they are among the best in the world at privacy and at compliance. And I mean, they're just good at it. They happen to be our attorney, but they're by ours, I mean my business, my company, and they're good member partners of the ECAC, and they're always willing to step up. But I will tell you that if you have any issues, one of the first places that you can look is with Aaron and with MS Law. Having said that, then I would say that Callie, we're about ready to wrap it up. And unless Aaron, you got any final thoughts?
Well, yeah. So first, thanks so much to the ECAC and Bob and Kaylee for putting this event together and inviting us to speak. And then, yeah, privacy is tough. There's a lot of stringent requirements, but with the right team, it's easily treadable and can certainly become a advantage. So I appreciate your invitation and please, if any questions arise, let me know.
We're always grateful to our member partners. So having said that, Callie, if we're finished, we're finished. Thank you.